Ready, start. On 22/1/2021, the bank issued an auction sale notice accordance with Rule 8 read with Rule 9 of the Security Interest Enforcement Rules 2002 for sale of the secured subject property for recovery of rupees 4,55,64,590.20 due and payable as on 31/12/2020. On 22/3/2021, upon payment of the entire sale consideration, the bank issued a sale certificate in favor of the appellants. The sale consideration received by the bank was appropriated towards the outstanding loan amount. In March 2021, after the sale came to be confirmed, the borrowers paid a sum of rupees 2,88 lakh towards the outstanding dues under the loan. It is pertinent to note that at the relevant point of time, an amount of rupees 61,91,000 was still outstanding towards the loan amount. After the completion of sale and issuance of the sale certificate, the DRT passed an order of status quo dated 26/3/2021. Since the appellants herein were not made party to the proceedings before the DRT proceeded to pass an order of status quo despite the fact that the appellants herein were not made party in the said proceedings. Later, an application for impleadment was filed by the appellants in the proceedings before the DRT. On 7/5/2021, the borrowers paid an amount of rupees 62,74,123.74 towards the outstanding dues for releasing the other properties. On 7/5/2021, the bank closed the loan account of the borrowers after appropriating a sum of rupees 1,25,60,000 received by it out of the sale consideration on auction of the secured assets as aforesaid. On 14/7/2021, the application for impleadment filed by the appellant came to be allowed. Thus, in spite of the authoritative pronouncement of the Honorable Supreme Court of India, the DRT has been time and again holding that the right of redemption is lost on the fall of the hammer as per Section 13(8), which is legally unsustainable and therefore only in the extraordinary circumstances as the question of law has to be made clear. This writ petition is entertained by this court and therefore the objection on the ground of alternative remedy, though is a valid objection and is also followed by this court generally in relegating the parties only to the DRT in view of the above peculiar and extraordinary circumstance, and because the contention of the borrowers/guarantors was not on air but by paying the entire sum outstanding to the bank as an exceptional case, this writ petition is entertained by this court and accordingly we overrule the said objection raised on behalf of the respondents. It is the objection of the respondent bank that initially, when the petitioners paid a sum of rupees 2,88 lakh in the month of March 2021 and thereafter rupees 62,74,123.74 on 17/5/2021, by accepting the sale of the property and by closing the loan account is concerned, except for the bald averment made therein, no material whatsoever is produced before this court. If such is the case, there would have been written communications to that effect on either side.